Hi folks, you're with Tacitus Today at your Pushback channel. What is it that prevents the state from arbitrarily putting a man in prison, from using the force of the state to take the liberty of an innocent man? Is it codified laws? Is it a free media, freedom of speech? Is it democracy? Is it all of these things? In fact, the corrupted state only has one major obstacle to overcome, and this is what we call due legal process. Without due legal process, any citizen can be arrested and imprisoned at the whim of the state. So what does due legal process mean? It means the state must prove its case using unimpeachable evidence. The accused has the right to examine, cross-examine, and then re-examine the evidence that the state relies upon. The state too has the same rights to competently examine the mitigating evidence put forward by the accused. All information, all witnesses, documents and material, and the advocacy to be used and relied upon must be equally available to all parties to the litigation. It is a jurist's role, that's a judge or a magistrate, it is a jurist's role to see that such legal process is adhered to. An independent jurist, that's again a judge or a magistrate, then is obliged to act with strict impartiality. They weigh the evidence, and sometimes with the assistance of a jury, they then issue a verdict. The jurist must then provide reasons for judgment, which can be later subject to appeal based on the reliability of the findings and or any misdirections that may have been given to a jury. It is when we understand due legal process and its role in any citizen's freedoms and liberties that we also understand what I believe to be the magnitude of miscarriage that occurred during the summary trial and imprisonment of Tommy Robinson in Leeds. But there is a wider question here. Why did a British court of law, engage in what many may now believe to be a determined and purposeful subversion of the very principles of procedural justice it is sworn under oath to uphold? Similarly, why was it no other custodian of the law, along with a veritable bevy of law watchers, not intercede or point out the manifest procedural unfairness of not only the process but the subsequent incarceration of Tommy Robinson? The mainstream media, the legal profession and the body politic moved in unison as one voice, one mindset and one view. Their collective condemnation of Tommy Robinson was vicious, and their gloating pleasure at Tommy Robinson's discomfort was completely unbefitting those who falsely claim to be impartial observers and are moral superiors. It's very unusual in a free speech, rule of law democracy to have such unanimous acceptance of opinion over a matter that's so controversial. Yet globalisation requires mass changing of human behaviour, and it is to the globalist elite that all the Western politicians now report. The globalists want to create more workers and consumers. The most effective way, they believe, is to bring unproductive and otherwise useless third world peasants to the West. The West is the stable engine room of wealth and job creation, so it's easier and cheaper all round to bring the peasants here to the West and plug them straight into their local economy. And this is in preference to, rather than throwing endless piles of cash at basket case failed economies and still getting nowhere. All the world's surplus populations, however, are black and brown, and many are peasant economies. So the white West must be reshaped, and whites must be cowed into accepting this new fate of forced mass immigration of black-brown peasants, and those local whites who may oppose such a racial displacement must be marginalised, demonised, and if necessary, crushed. It's not so easy to go about crushing citizens who have a view and opinions that are inconvenient to state socio-political objectives, but who have committed no tangible crime. Globalisation policy requires the mass changing of human behaviour and attitudes, which in turn requires coercive laws, and thus politicised rather than clearly codified law. Politicised law thus begets politicisation of law enforcement and indeed the court system. What the state therefore uses is a medieval legal practice known as attainder, A-T-T-A-I-N-D-E-R. They do not use the name, just the process. Courts of attainder treat the accused as already existing outside of the law, to be, in effect, pre-guilty, without a due legal process hearing. Consider the hysterical demonisation of Tommy Robinson and the callous use of the globalist scripted media to pre-condemn Tommy Robinson and any who may support him. Therefore, a court of attainder need only decide on the punishment to be meted out. But there is one more legal strand to this unallowable travesty: the tactical and, I believe, sinister use of contempt charges as the technical reason or politicised trigger for arbitrary incarceration. Citizens who have committed a misdemeanour or no crime at all, or where wrongdoing has not been proved by testing of evidence in a court of law, are now being slapped with court orders that restrict their movement or their freedom of association and or freedom of speech. Then, in an act of legal prestidigitation, that same person can be imprisoned or fined based on failure to comply with those court orders. Failure to comply with court orders is contempt of court, which can carry severe penalties. But the rub is the burden of proof that the state must meet to allege contempt and act upon it is very low. The evidence bar is low. Contempt is now the tactical weapon of choice and the means by which the state can lock up those citizens it disagrees with. It used to be that globalists and their stooges in Western governments and the deep state tried to hide this usurpation of due legal process, but no longer. The United Nations, that bastion of globalisation and leftism, has put a paper out requiring, in essence, the UN takes control of all global immigration and issues quotas to how many black and brown peasant immigrants the white Western nations have to take each year. Now, I'll leave a link below, but let me quote from the article, which was penned by journalist Chris Merritt in the Australian newspaper on August 3rd, 2018. And I'm going to read directly from this rather chilling document, as it indicates and portrays the reach of the globalists at this stage. Objective 17 requires governments to shape perceptions of migration by sensitising and educating journalists. And this is very chilling here: withholding public funding and material support from publications that promote intolerance of migrants or, by extension, any disagreement with mass migration. Objective 12, governments would need to subject judges, that's the judiciary, the judges and the magistrates, to specialised human rights and trauma-informed trainings. And this specialised human rights training should include the police, border officials such as customs and immigration, and consular staff working in the immigration and visa departments. This is the globalist agenda, and it's out in the open. There's no secret anymore. A court of law and due legal process are not playthings to be corrupted and debased at the whim of politicians or the UN or anyone else who no longer believe they represent the people. Should any politicians not support or be an enemy of due legal process, then vote them out of office. The hue and the cry from the Houses of Parliament in Westminster at Tommy Robinson's detention should have been a crescendo, not because of any agreement or disagreement with any views expressed by Tommy Robinson, but because elected lawmakers are the sworn protectors of our laws. If they're not protecting those laws, and therefore the rights of every citizen, then they have no business sitting in the British Parliament and permitting procedural corruption of British courts of law. In the name of God, be gone. You've been with Tacitus Today. Thank you for listening.